Ma'am, just asking you on the Bhanwari Devi case that led to the Vishaka guidelines, why that case in particular you think led to forming a whole new guideline on workplace harassment?
Yeah, that's because Bhanwari Devi, when she was raped in retaliation, she was only carrying out her job, which was to stop child marriage. So she tried to stop this child marriage. They were upper caste people, they retaliated and they raped her. Now, the thing before the court was originally it was only the CBI inquiry, what they wanted, all the NGOs wanted. But the day the case came up before the court the first time, the morning newspaper reported that the Rajasthan government had already accepted the CBI inquiry. So the relief, what was the main relief in the petition, no longer survived. But this other prayer that we had in the petition, that if a woman in course of discharge of her work duties is subjected to an assault or is subjected to something as gruesome as it, does the employer not have an obligation to protect and to see that she is first of all not exposed to such a danger while performing her job? Number two, if she is exposed to that danger, then put in place protection measures, and if then something happens, please provide for her, take care of her, take for what has happened. So there was nothing of this kind in law at that given point in time. And that was the small ground in the petition and a relief prayed for in the petition. Now, the CBI inquiry was no longer necessary, and the judge said, but we are very, actually, the first day when the matter came up, they said, your main relief is now infructuous, there's nothing survives, but we are interested in this and come to this particular paragraph, and we want to do something about it. So that's where it all started, and it was a nebulous idea, if I may be very candid today. But this was 1992, and in between 92 and the judgment came in 97. So by the way, you had some very progressive judges in between, Justice Venkatchalaya and Justice J.S. Verma, who were singularly responsible for seeing this through. So between that, India ratified CEDAW, that's Convention on Elimination of Discrimination Against Women. While they ratified CEDAW, which is an international convention, they actually never legislated in India to provide for the same thing in the domestic law. And so at the same time, there was a Beijing conference, and one of our judges who was on that particular bench, Justice Sujata Manohar, she attended the Beijing conference, and she came back with the whole lot of ideas on this. So there were many things that happened within that course of 5 years, and the judges felt that if the government is not going to legislate, now this is actually something India got recognized world over for taking this position in law, that if a government ratifies an international convention on rights, but chooses then not to legislate or bring those rights into the domestic country by not giving a legislation, then the court will hold that particular rights in its guidelines till such time as you frame a legislation. So Supreme Court, that's what the Supreme Court did. It took the CEDAW guidelines and we all structured them together. Mr. Nariman was really, huge support for all of us, F.S. Nariman, and we formulated the guidelines, the court accepted them, put them in its judgment, with a small caveat that those guidelines will hold the field till the government legislates. Mm-hmm. And they held the field for 16 years. Mm. Now, Kunal, that's a very important thing for you.
Yeah.
It took our government 16 years to legislate. That's how much we think about women's right in the parliament.
Yeah.